Welcome back to HOA Checkmate. They called it a clerical error and I called it a pattern. Cynthia waved a motion log and screamed that motions could be added after the meeting. I love paperwork, and you are giving me a reason. She was standing in the community center parking lot, rain-slick asphalt reflecting the overhead lights, her face twisted in that specific kind of rage that comes from being challenged on procedure. The motion log in her hand was a plastic evidence sleeve she kept waving like it proved everything. But I had seen that sleeve before, years ago, in a different fight that never made sense. I pulled my phone out of my jacket pocket and started recording. She screamed louder. I kept my voice flat. My elderly parent was staying with me, and the stress was making everything harder, and I was not about to let this escalate without proof. Eagle Ridge HOA Incorporated, Sioux Falls, South Dakota. I work as a commercial photographer, so I always have a camera and extra batteries. I had moved here 5 years ago thinking a quiet suburb would be manageable. But Cynthia Young, welcome committee chair, had weaponized move-in rules into a compliance empire. The violation notice had arrived that morning, rubber-banded to my mailbox post. A violation notice that reads like a ransom note with a deadline that makes no sense. The alleged infraction was parking a commercial vehicle overnight, but I drive a sedan. The notice referenced a rule page that I had never seen. I checked my HOA packet from Move-In. The page was missing. I called the management company. They put me on hold for 11 minutes, then told me they would email me the rule. The email never came. I called back. Different staffer. She said the rule was under review and she could not send it until the board finalized it. I asked when that would be. She said she did not know. I asked for the current version. She said it was not available. I hung up and drove to the management office. The lobby was beige and fluorescent, with a fake plant in the corner and a bulletin board covered in HOA meeting minutes that no one ever read. I walked up to the counter and asked for a copy of the parking rule. The clerk looked at me like I had asked for nuclear launch codes. She said she would have to check with her supervisor. I waited. The supervisor came out, a tired woman in a polo shirt with the management company logo. She asked what I needed. I repeated the request. She said the rule was in the master binder and she could not photocopy it without board approval. I asked why a homeowner needed board approval to see a rule that was supposedly already in effect. She said that was the policy. I asked to see the policy. She said it was not written down. I asked if I could photograph the binder page. She said no. I asked if I could read it in the lobby. She hesitated, then said she would bring it out. She came back 5 minutes later with a 3-ring binder, tabs sticking out in every direction, no organization. She opened it to a section labeled Parking. I scanned the pages. The rule Cynthia kept citing was not there. I pointed that out. The supervisor flipped through, frowning. She said it must be misfiled. I asked if she could search the digital records. She said they did not have digital records for rules adopted before 2019. I asked when the rule was adopted. She said she did not know. I asked if she could check the meeting minutes. She said that would take time. I said I had time. She said she had other clients. I said I would wait. She closed the binder and walked away. I stood there for 10 minutes. Another homeowner came in, asked a question about landscaping fees, got an answer in 30 seconds, and left. I waited. The supervisor came back and said she could not locate the rule and I should contact the board president. I asked for the board president's contact. She wrote a phone number on a sticky note and handed it to me. I thanked her and left. I called the number from my car. Voicemail. I left a message. No callback. I called the next day. Voicemail again. I left another message. Still no callback. I sent an email to the address listed on the HOA website. Bounce back. Domain expired. I drove back to the management office. Different clerk. I asked for the board president's current email. She said she could not give out personal information. I said it was HOA business. She said she still could not. I asked if she could forward my message. She said she would try. I never got a reply. The second violation notice arrived 3 days later. Same parking complaint. This time the fine was $250, and the notice said my vehicle would be towed if not moved within 24 hours. I did not have a commercial vehicle. I took photos of my sedan with the license plate visible and the timestamp showing. I emailed them to the management company with a polite explanation. Auto reply. Office closed for the holiday weekend. It was Wednesday. I called. Voicemail. I drove to the office. Locked. Sign on the door said they would reopen Monday. The tow deadline was Friday night. I went home and searched my move-in packet again. I found the welcome letter Cynthia had signed. It referenced a community handbook. I checked the packet. No handbook. I called 3 neighbors. None of them had received a handbook either. One of them, a guy who had lived there for 8 years, said he had tried to get a copy once and Cynthia told him it was only for new residents. He said he was a new resident when he moved in and never got one. I asked if he had ever been cited for a violation. He said no, but he kept his head down and followed the unwritten rules. I asked what those were. He said whatever Cynthia decided that week. I pulled up the HOA group chat on my phone. I had joined it during move-in thinking it would be helpful community updates. Instead, it was a constant stream of Cynthia tagging people for minor infractions and rallying neighbors to sign complaints. I scrolled back through the last 6 months. I found a pattern. Every enforcement wave started with Cynthia posting a vague concern, then tagging a specific homeowner, then asking who else had noticed the problem. Within hours, multiple people would reply agreeing, even if the issue was invisible. I took screenshots. I found one thread from 2 months ago where Cynthia had posted about overnight commercial vehicles, and 3 people immediately replied that they had seen them, but no one specified an address or a date. The thread ended with Cynthia saying she would handle it. 2 weeks later, a neighbor I barely knew got a tow notice. He moved out a month after that. I called a local news tip-line staffer I knew from a freelance gig. I explained the situation. She said it sounded like selective enforcement and possibly harassment, but unless I could prove a pattern with documentation, it was just a neighbor dispute. I said I had screenshots. She said screenshots of a group chat were not enough unless they showed coordination with the management company or the tow vendor. I asked how I would get that. She said records requests, vendor contracts, meeting minutes, anything that showed the HOA and the vendor working together to target specific people. I thanked her and hung up. I filed a records request with the management company. I asked for all parking violation notices issued in the last 2 years, all towing invoices, all contracts with the tow vendor, and all meeting minutes that mentioned parking enforcement. The request went unanswered for a week. I followed up. The supervisor called me back and said the records were not centralized and it would take time to compile them. I asked how much time. She said at least 30 days. I said the violation deadline was in 2 days. She said that was separate. I said I needed the records to dispute the violation. She said I could dispute it at the next board meeting. I asked when that was. She said it was not scheduled yet. I said the website listed monthly meetings. She said they had moved to quarterly meetings. I asked when the next one was. She said she would check and get back to me. She never did. I kept my hands open and my voice calm, because the real move was still ahead. I had started digging into the old case, the one that had never made sense. 3 years ago, a homeowner named Marcus had been cited for the same commercial vehicle violation. He drove a pickup truck with a toolbox in the bed. Cynthia claimed it was a commercial vehicle. Marcus said it was personal. The board upheld the violation. Marcus paid the fine, then sold his house 6 months later. I had met him once at a neighborhood cookout before he left. He had seemed defeated, like the fight had drained him. I found his contact info in an old email thread and reached out. He called me back the same day. Marcus said the whole thing had been a setup. He said Cynthia had targeted him because he had questioned her authority at a meeting. He said the violation notice had appeared the next week. He said he had requested the rule and never got it. He said he had asked to see the meeting minutes where the rule was adopted and was told they were lost. He said he had hired a lawyer, and the lawyer had requested the same records. The management company had stalled for months, then provided a single page with no date, no signatures, and no context. The lawyer said it was not enough to fight, and Marcus should just pay the fine and move on. Marcus said he regretted not pushing harder. He said he suspected Cynthia had fabricated the rule entirely, but he had no proof. I asked if he still had any of the paperwork. He said he had thrown it out when he moved. I thanked him and told him I would keep him updated. I went back to the group chat screenshots. I searched for Marcus's name. I found the thread from 3 years ago. Cynthia had posted that commercial vehicles were becoming a problem and asked if anyone had noticed trucks parked overnight. 5 people replied immediately, all agreeing. One of them tagged Marcus directly. Cynthia replied that she would look into it. The next post was 2 weeks later, Cynthia announcing that the board had voted to enforce the commercial vehicle rule more strictly. No mention of a meeting. No minutes posted, just an announcement. I took more screenshots. I searched the HOA website for meeting minutes from that time period. I found a gap. The minutes from April through July of that year were missing. The minutes before and after were posted, but those 4 months were gone. I called the management company and asked for copies. The clerk said she would check. She called back an hour later and said the minutes were not in the system. I asked why. She said sometimes minutes were not submitted if there was no quorum. I asked if there was a record of canceled meetings. She said no. I asked if I could request the audio recordings. She said meetings were not recorded. I said the bylaws required recordings. She said that was a new rule and did not apply retroactively. I said I wanted the old minutes anyway. She said she could not provide what did not exist. I hung up. I pulled up the bylaws on the HOA website. I searched for the word recording. The rule was there, adopted 2 years ago. I searched for the word minutes. The rule required minutes to be posted within 10 days of each meeting. I checked the website archive using a web tool. The minutes from that gap period had never been posted. I took screenshots of the archive showing the missing months. I added them to my evidence folder. The board packet is being finalized this afternoon, and I have to get my evidence included before it is sealed. I called the management company and asked if I could submit a dispute before the next meeting. The clerk said the next meeting was not scheduled. I said I had a deadline. She said I could email my dispute and they would forward it to the board. I said I wanted confirmation that it was received and included. She said she could not guarantee that. I said I would deliver it in person. She said the office closed at 4. I looked at the clock. It was 3:15. I grabbed my evidence binder and drove. I arrived at 3:50. The lobby was empty except for the same tired supervisor from before. I handed her the binder and said I needed to submit a formal dispute of the parking violation. She looked at the binder like it was a live grenade. She said she could not accept it without board authorization. I said the bylaws allowed homeowners to submit disputes at any time. She said that was for the old board. I said the bylaws had not changed. She said the process had. I asked to see the new process. She said it was not written down yet. I said I would wait until it was. She said that could take months. I said I had a tow deadline in 2 days. She said that was separate. I opened the binder and pointed to the timeline. I showed her the violation notice with no rule citation. I showed her the missing handbook. I showed her the group chat screenshots showing coordination. I showed her the missing meeting minutes. She stared at the pages, her face pale. She said she would forward it to the board president. I said I wanted a receipt. She said she did not have a form. I said she could write one. She grabbed a sticky note and scribbled received dispute package and signed it with her initials. I took a photo of the note. I thanked her and left. I sat in my car and called the tip line staffer again. I told her I had submitted the evidence. She said good, but it still was not enough to prove coordination unless I could link the management company and the tow vendor directly. I said I was working on it. She said I had 2 days. I said I knew. That night I drove to the tow yard. It was a chain-link lot on the edge of town, rows of impounded cars under bright floodlights. I walked into the office, a prefab trailer with a window cut into the side. A clerk sat behind bulletproof glass, watching a small TV. I asked if they handled towing for Eagle Ridge HOA. He said, yeah. I asked if I could see the contract. He said no. I said I was a homeowner and I wanted to know the terms. He said the contract was between the HOA and the company, not individual homeowners. I asked if he could tell me how violations were reported. He said the HOA called them with an address and a description, and they picked up the vehicle. I asked if they verified the violation. He said that was not their job. I asked what happened if the violation was wrong. He said the homeowner could dispute it with the HOA. I said, what if the HOA lied? He shrugged. I asked if he kept records of the calls. He said they had dispatch logs. I asked if I could see them. He said no. I asked if a lawyer could subpoena them. He said probably. I thanked him and left. I sat in my car and searched for the tow company name on my phone. I found their website. I found a news article from 2 years ago about a lawsuit. A different HOA had sued them for towing vehicles without proper notice. The case had settled. The terms were confidential. I kept searching. I found a review site. Dozens of one-star reviews, all from people claiming wrongful tows. I found one review from someone in Sioux Falls. The review mentioned Eagle Ridge HOA by name. The reviewer said their car had been towed in the middle of the night with no warning, and the tow company refused to release it without payment. The reviewer said they had called the HOA and no one answered. The reviewer said they had to pay $300 to get their car back. I took a screenshot. I called the reviewer. The number was in their profile. A woman answered. I explained who I was and why I was calling. She remembered the incident. She said it had happened 18 months ago. She said she had parked in a guest spot and the next morning her car was gone. She said she called the tow company and they said the HOA had reported it as an unauthorized vehicle. She said she called the HOA and left 3 messages. No callback. She said she went to the management office and they said they had no record of the tow. She said she paid the fee and got her car back. She said she sold her house 2 months later. I asked if she still had any paperwork. She said no. I thanked her and hung up. I pulled up the group chat again. I searched for her name. I found a thread from the week before her car was towed. Cynthia had posted about unauthorized guest parking and asked if anyone had noticed unfamiliar vehicles. 3 people replied. One of them mentioned a car in a guest spot with out-of-state plates. Cynthia replied that she would look into it. The next post was the woman asking why her car had been towed. Cynthia replied that guest spots were for guests only, and overnight parking required a pass. The woman replied that she was a homeowner and did not know about the pass requirement. Cynthia replied that ignorance was not an excuse. The thread ended. I took screenshots. I searched the HOA website for guest parking rules. Nothing. I searched the bylaws. Nothing. I called the management company. I asked about guest parking passes. The clerk said they did not issue passes. I asked if there was a rule requiring them. She said she did not think so. I asked if she could check. She put me on hold. She came back and said there was no rule. I asked if there had ever been a rule. She said she did not have access to historical records. I asked who did. She said the board president. I asked for the contact again. She said she could not give it out. I hung up. The next morning, Cynthia showed up at my door. She was wearing her blue windbreaker with the hood up even though it was not raining, and a white baseball cap pulled low. She had a clipboard in one hand and a laminated rule card in the other. She said she was there to inspect my vehicle. I said I did not consent to an inspection. She said the HOA had the right to verify compliance. I said, show me the rule. She waved the laminated card but kept it angled away so I could not read it. I pulled out my phone and started recording. She screamed that I could not record her without permission. I said we were on my property and I could record whatever I wanted. She said she would call the police. I said, go ahead. She did not move. I asked her to show me the parking rule. She said it was in the handbook. I said I never received a handbook. She said that was my problem. I said the management company confirmed they did not have a copy. She said they were lying. I said, show me the rule. She flipped the laminated card around. It was a printed page with no header, no date, no signatures. Just a paragraph of text saying commercial vehicles were prohibited from overnight parking. I asked when the rule was adopted. She said years ago. I asked for the meeting minutes. She said they were archived. I said the management office could not find them. She said I was not looking hard enough. I asked her to provide them. She said she did not have to. I said if the rule was not documented, it was not enforceable. She said if you make me repeat myself, it gets more expensive. She turned and walked to my driveway. She took photos of my car with her phone. I asked what she was doing. She said documenting the violation. I said there was no violation. She said the vehicle was commercial. I said it was a sedan. She said the rule applied to any vehicle used for business purposes. I said I was a photographer and I used my car to drive to shoots, but that did not make it a commercial vehicle. She said that was my interpretation. I said, show me the definition in the rule. She said it was implied. I said implied rules were not enforceable. She said the board would decide. I said when. She said soon. I said I had a tow deadline tomorrow. She smiled and said I should move the car then. I asked where I was supposed to move it. She said, off the property. I said I owned the property. She said the HOA owned the streets. I said the streets were public. She said the HOA had an agreement with the city. I said, show me the agreement. She said it was confidential. I said public agreements could not be confidential. She said I could file a records request. I said I already did. She said it was being processed. I said it had been 2 weeks. She said these things take time. I said the tow deadline was tomorrow. She said I should have thought of that before I violated the rule. I said I did not violate anything. She said the board disagreed. I said the board had not met. She said they had an emergency session. I said when. She said last night. I said where were the minutes? She said they would be posted. I said when. She said within 10 days. I said the tow was tomorrow. She said that was my problem. She walked back to her car. I followed her with my phone still recording. She got in and slammed the door. She rolled down the window and said, I do not need proof. I have paperwork and vibes. She drove off. I stood in my driveway and reviewed the recording. Her voice was clear. The laminated card was visible, but unreadable. Her claim about the emergency session was recorded. I saved the file and emailed it to myself as backup. I called the management company. I asked if there had been an emergency board meeting last night. The clerk said she did not have that information. I asked who would. She said the board president. I asked for the contact. She said she could not provide it. I said this was the 3rd time I had asked. She said policy had not changed. I asked to speak to her supervisor. She put me on hold. The supervisor came on and asked what I needed. I explained the situation. She said she would check the meeting schedule. She put me on hold. She came back and said there was no record of an emergency meeting. I asked if one could have happened without being recorded. She said technically yes, but it would still need to be documented. I asked if it had been documented. She said not that she could see. I asked if Cynthia had the authority to call an emergency meeting. She said only the board president could. I asked if Cynthia was the board president. She said no, Cynthia was the welcome committee chair. I asked what authority that gave her. She said it was mostly ceremonial. I said she was issuing violation notices. The supervisor was quiet for a moment. She said she would look into it. I said I had a tow deadline tomorrow. She said she understood. She hung up. I called the tow company again. I asked if they had received a tow order from my address. The clerk said he could not give out that information. I said it was my address. He said it did not matter. I said I wanted to prevent a wrongful tow. He said if I thought it was wrongful, I should talk to the HOA. I said the HOA was lying. He said that was not his problem. I said I would file a complaint. He said go ahead. I hung up. I spent the rest of the day documenting everything. I printed the group chat screenshots. I printed the timeline. I printed the violation notices. I printed the emails. I printed the web archive showing the missing minutes. I organized everything into a binder with tabs. I made copies. I put one set in my car. I put one set in my office. I scanned everything and uploaded it to a cloud drive. I was not going to let them erase the evidence. That night I could not sleep. I kept thinking about Marcus, about the woman with the towed car, about how many other people had been targeted and gave up. I kept thinking about my parent upstairs, stressed and anxious because of the chaos. I kept thinking about Cynthia's face when she said, "I do not need proof, I have paperwork and vibes." I got up and went to my office. I pulled up the group chat again. I scrolled back further, past the Marcus incident, past the towed car, back to the earliest messages. I found the thread where Cynthia had been appointed Welcome Committee Chair. It was 5 years ago. The board president at the time had announced it in a post. The replies were congratulatory. One person asked what the role involved. Cynthia replied that she would be handling new resident orientation and compliance monitoring. Someone asked what compliance monitoring meant. Cynthia replied that she would be ensuring everyone followed the rules. Someone asked which rules. Cynthia replied all of them. The thread ended. I searched the bylaws for the Welcome Committee. Nothing. I searched the Articles of Incorporation. Nothing. I searched the website. The only mention was Cynthia's name listed under committees. No description of duties, no term limits, no oversight. I went back to the group chat. I searched for the word committee. I found dozens of references. Cynthia always referred to herself as the compliance chair or the welcome chair interchangeably. No one ever corrected her. No one ever questioned her authority. She had built an enforcement apparatus out of a ceremonial role, and no one had stopped her. I found a thread from 4 years ago where someone had asked how to appeal a violation. Cynthia had replied that appeals went to the compliance committee. Someone asked who was on the committee. Cynthia replied that she was the chair and would appoint members as needed. Someone asked if there were any current members. Cynthia never replied. I took a screenshot. The tow truck arrived at 6 in the morning. I was already awake, sitting in my car with the engine off, phone recording. The driver pulled up and got out. He was a big guy in a company jacket, holding a clipboard. He walked up to my car and knocked on the window. I rolled it down. He said he had an order to tow this vehicle. I said, on what grounds? He said, HOA violation. I said, show me the order. He showed me the clipboard. It was a printed form with my address, my plate number, and a box checked for unauthorized commercial vehicle. I said the vehicle was not commercial. He said that was not his call. I said I was disputing the violation. He said I needed to do that with the HOA. I said the HOA had not provided the rule. He said he was just doing his job. I said I would not move. He said he would tow it with me in it if he had to. I said that was illegal. He said he did not think so. I called the police. The dispatcher said they would send someone. I stayed in the car. The driver stood next to his truck, arms crossed. We waited. A patrol car pulled up 15 minutes later. A deputy got out, young guy with a notebook. He asked what was going on. I explained the situation. The driver said he had a legal tow order. I said the order was based on a fabricated violation. The deputy asked if I had proof. I showed him my phone with the recording of Cynthia. I showed him the binder. I showed him the missing handbook, the missing minutes, the group chat screenshots. He flipped through the pages, frowning. He asked the tow driver if he had verified the violation. The driver said that was the HOA's job. The deputy asked if the HOA had provided documentation. The driver showed him the clipboard. The deputy looked at the form. He asked if there was a rule citation. The form was blank in that field. The deputy asked the driver to call his dispatch. The driver walked back to his truck and got on the radio. I could hear him talking, but could not make out the words. He came back and said dispatch confirmed the order came from the HOA. The deputy asked for a name. The driver said he did not have one. The deputy asked for a callback number. The driver gave him the management company number. The deputy called it. Voicemail. He left a message. He turned to me and said he could not stop the tow without confirmation that the order was invalid. I said the order was based on a rule that did not exist. He said that was a civil matter. I said it was fraud. He said I would need to prove that in court. I said I was trying to prevent the tow so I did not have to go to court. He said he understood, but his hands were tied. He suggested I move the vehicle voluntarily and dispute the violation through the HOA process. I said the HOA process was rigged. He said that was above his pay grade. The driver hooked up my car. I got out and stood on the curb, recording everything. A neighbor walked by, watering the lawn, and paused mid-spray to stare. The driver loaded my car onto the flatbed. I asked where he was taking it. He gave me the address of the tow yard. I asked how much it would cost to get it back. He said $350. I said that was extortion. He said that was the fee. He drove off. The deputy said he was sorry he could not do more. I said it was not his fault. He got back in his patrol car and left. I stood alone in my driveway, watching my car disappear down the street. If you are enjoying this HOA nightmare, smash that like button and subscribe so you do not miss the payback. I walked inside and sat at my kitchen table. My parent came downstairs and asked what had happened. I explained. They looked horrified. They asked if we were going to be okay. I said yes. They asked how. I said I was working on it. They went back upstairs. I sat there staring at my phone. I had the recording. I had the evidence binder. I had the screenshots. But none of it had stopped the tow. I needed something bigger. I needed the smoking gun. I called the tip line staffer. I told her what had happened. She said I needed to escalate. I said to who? She said the state attorney general's office handles HOA complaints. I said this was beyond a complaint. She said file it anyway. She said if I could prove the management company was coordinating with the tow vendor to fabricate violations, that was fraud, and the AG would investigate. I asked how to prove it. She said I needed internal communications, emails, texts, recorded calls, anything showing intent. I said I did not have access to that. She said records requests could force it. I said records requests took months. She said there was another way. She said if the management company kept sloppy records, they might accidentally release something they should not have. She said request everything. Be specific, and hope they mess up. I thanked her and hung up. I drafted a new records request. I asked for all communications between the management company and the tow vendor in the last 3 years. I asked for all violation notices issued for parking infractions. I asked for all meeting minutes mentioning parking enforcement. I asked for all contracts and agreements with the tow vendor. I asked for all emails and memos referencing my address. I sent it certified mail. I sent a copy to the board president at the address listed on the website, even though I knew it was probably wrong. I sent a copy to Cynthia at her home address, which I found in the HOA directory. I sent a copy to the Attorney General's office with a cover letter explaining the situation. I sent a copy to the local news tip line. I was done playing nice. 2 days later, I got a call from the management company's supervisor. She sounded rattled. She said they had received my records request and it was overly broad. I said it was specific. She said it would take months to compile. I said I would wait. She said some of the records might be privileged. I said HOA records were not privileged. She said attorney-client communications were. I said show me which records fell under that. She said she could not without revealing the contents. I said that was circular reasoning. She said she was trying to help. I said then release the records. She was quiet for a long moment. She said she would talk to her supervisor. I said I wanted a timeline. She said she would get back to me. She hung up. I called the tow yard. I asked if they had received any records requests. The clerk said no. I said they would. He said okay. I asked if he was required to comply. He said he did not know. I said he should check with his boss. He said he would. I hung up. I called a lawyer. I explained the situation. He listened, asked a few questions, and said it sounded like a pattern of harassment and possibly fraud. He said he could take the case on contingency if I was willing to go to court. I said I was. He said the first step was to formalize the records request with a subpoena. I said I had already filed a request. He said that was good, but not enforceable. I asked what I needed. He said a lawsuit. I asked how much that would cost up front. He said $2,000 for filing fees and initial discovery. I did not have $2,000. He said he could waive his fees if I agreed to a percentage of any settlement. I said, what if there was no settlement? He said, then we both lost. I said I would think about it. He said, do not wait too long. Evidence has a way of disappearing. I hung up. I went back to the group chat. I searched for the word tow. I found 37 mentions over the last 3 years. Most of them were Cynthia announcing that a vehicle had been towed or would be towed soon. A few were homeowners asking why their car was gone. None of the replies explained the process. None of them cited a rule. They all just said the HOA had the right to enforce compliance. I took screenshots of every thread. I found one thread from 18 months ago, right around the time the woman's car had been towed. Cynthia had posted a photo of a car in a guest spot. The photo was taken at night, poorly lit, just enough to see the license plate. Cynthia had written, "Does anyone know who this belongs to?" 3 people replied no. One person said it had been there for 2 days. Cynthia replied, "Thanks, I will take care of it." The next morning, the woman posted asking why her car was towed. I looked at the timestamps. The tow happened 6 hours after Cynthia's post. I took a screenshot. I searched the tow company website for their terms of service. I found a section on HOA contracts. It said they required written authorization for every tow, including the violation type, the rule citation, and the homeowner notification date. I took a screenshot. I called the tow yard and asked if they had written authorization for my tow. The clerk said yes. I asked to see it. He said it was internal. I said the terms of service required it. He said that was between the company and the HOA. I said I was the affected party. He said I could request it through the HOA. I said the HOA would not provide it. He said that was not his problem. I hung up. I filed a complaint with the State Attorney General's office. I attached all my evidence, the screenshots, the timeline, the recordings, the violation notices, the missing handbook, the missing minutes, the tow order with no rule citation. I wrote a cover letter explaining the pattern, fabricated rules, selective enforcement, coordination between the HOA and the tow vendor, missing records, and a rogue committee chair operating without oversight. I asked for an investigation. I sent it certified mail. I got a tracking number. I checked it every day. 3 weeks later, I got a letter from the AG's office. It said they had reviewed my complaint and determined it was a private civil matter outside their jurisdiction. It said I should consult an attorney or file a lawsuit. It said they could not intervene in HOA disputes unless there was evidence of criminal activity. I read the letter 3 times. I wanted to scream. I called the tip line staffer. She said that was standard. She said the AG's office was understaffed and only took cases with overwhelming evidence of fraud. I said I had evidence. She said I had circumstantial evidence. She said I needed a confession, a forged document, or a money trail. I said, how was I supposed to get that? She said, keep digging. I went back to the binder. I went through every page again, looking for something I had missed. I found a detail in one of the group chat screenshots. Cynthia had posted about a board vote to increase towing enforcement. The post was dated 6 months before Marcus's car was towed. But the meeting minutes from that month showed no such vote. I pulled up the minutes. The agenda listed standard items, budget review, landscaping contract, pool maintenance. No mention of towing. I checked the minutes from the month before. Nothing. The month after. Nothing. I checked the entire year. No vote on towing enforcement anywhere. I called Marcus. I asked if he remembered Cynthia ever mentioning a board vote. He said no. I asked if he had requested the meeting minutes when he was fighting his violation. He said yes. I asked what they had showed. He said the management company sent him a single page with a vote summary. I asked if it had signatures. He said no. I asked if it had a date. He said just the month. I asked if he still had it. He said he thought he had thrown it out, but he would check. I gave him my email. He said he would look and get back to me. 2 days later, Marcus emailed me a photo. It was a crumpled piece of paper, a printed vote summary. The header said Board Vote Summary, and the body listed a single item. Motion to increase enforcement of parking violations, approved 4-0. No date, no signatures, no meeting number. Just a floating piece of paper with no context. I compared it to the official meeting minutes from that month. The format was completely different. The official minutes had headers, footers, page numbers, and signatures. This summary had none of that. It looked like someone had typed it in Word and printed it. I opened the image file properties. The metadata showed it was created 2 days before Marcus received it. The meeting it supposedly documented had happened 6 months earlier. I took screenshots of the metadata. I called Marcus and told him. He was silent for a long moment. He said they had backdated it. I said it looked that way. He said he wished he had known. I said it was not too late. He said he had already sold his house. I said I had not. He said good luck. I thanked him and hung up. I added the photo and the metadata screenshots to my binder. I now had proof that the management company had fabricated meeting minutes. I called the lawyer back. I told him what I had found. He said that was fraud. I said that was what I thought. He said we could file a lawsuit and subpoena the original meeting records. I said, what if the originals did not exist? He said then we would prove they were destroyed, which was spoliation of evidence. I said, how long would that take? He said months, maybe a year. I said I did not have a year. He said then I needed to force their hand. I asked how. He said find a way to make them produce the records voluntarily, or catch them in a lie. I said I was trying. He said try harder. I hung up. I went to the next HOA event, a neighborhood cleanup day. It was a Saturday morning. Volunteers with trash bags and gloves picking up litter along the community walking path. Cynthia was there, clipboard in hand, directing people like a general. I walked up with my phone recording. I asked her about the board vote on towing enforcement. She said it was a matter of record. I said the minutes did not show it. She said I was looking at the wrong minutes. I asked which minutes I should be looking at. She said the executive session minutes. I said executive sessions were for legal and personnel matters, not policy votes. She said the board decided what qualified. I asked to see the executive session minutes. She said they were confidential. I said the bylaws required all votes to be recorded in open session. She said I was misinterpreting the bylaws. I asked her to show me the correct interpretation. She said if you make me repeat myself, it gets more expensive. I kept recording. A neighbor walked up, a middle-aged guy I had seen around, but never talked to. He said he had been on the board 2 years ago, and there was no vote on towing enforcement. Cynthia turned on him. She said he was misremembering. He said he had kept his own notes. She said his notes were not official. He said neither were hers. She said she was the compliance chair. He said that did not give her authority to fabricate votes. She screamed that he was calling her a liar. He said if the shoe fits. She turned and walked away, muttering under her breath. I thanked the guy. He said Cynthia had been pulling this stuff for years, and no one had the guts to call her out. I asked if he would be willing to go on record. He said absolutely. I got his contact info. I reached out to 3 other former board members whose names I found in old meeting minutes. One did not respond. One said she did not want to get involved. One, a retired accountant named Linda, said she would talk. I met her at a coffee shop. She said she had been treasurer 3 years ago and quit because Cynthia made it impossible to do the job. I asked what she meant. She said Cynthia kept demanding emergency expenditures without board approval. I asked for what? She said enforcement actions, mostly towing and legal fees. I asked if the expenditures were documented. She said barely. She said Cynthia would submit handwritten receipts with no backup. Linda said she had pushed back, and Cynthia had accused her of obstructing compliance. The board president at the time had sided with Cynthia. Linda resigned a month later. I asked if she had kept any records. She said she had her treasurer files in a box in her garage. I asked if I could see them. She said sure. We drove to her house. She pulled out a banker's box full of spreadsheets, receipts, and email printouts. I started going through it. I found a receipt from the tow company, dated 2.5 years ago, for $600. The memo line said multiple violations. No detail. I found another receipt, same company, 8 months later, $450. Same vague memo. I found a third receipt, a year ago, $350. I took photos of all of them. I asked Linda if the board had approved these expenditures. She said no. She said Cynthia had submitted them after the fact, and the board president had rubber-stamped them. I asked if Linda had objected. She said yes, in writing. I asked if she still had the emails. She dug through the box and pulled out a printout. It was an email chain between Linda and the board president. Linda had written that the towing expenditures were not budgeted and had no supporting documentation. The president had replied that compliance was a priority, and the board trusted Cynthia's judgment. Linda had replied that trust was not an audit trail. The president had not responded. I took a photo. Linda said there was more. She pulled out a folder labeled Discrepancies. Inside were printouts of bank statements and her own handwritten notes. She said she had noticed that the tow company invoices did not match the bank withdrawals. The invoices totaled over $2,000 that year, but the bank showed $3,000 in payments to the tow company. I asked where the extra money went. She said she did not know. She said she had asked Cynthia, and Cynthia had said it was a budgeting error. Linda had asked for clarification. Cynthia had said she would look into it. She never did. Linda had raised it with the board president. The president had said it was not significant enough to worry about. Linda had disagreed. The president had suggested Linda was too detail-oriented for the role. Linda had resigned the next week. I asked if she had reported it to anyone. She said no. She said she did not have proof of wrongdoing, just inconsistencies. I asked if I could take copies of everything. She said take the whole box, she did not need it anymore. I loaded it into my car and thanked her. She said she hoped I nailed Cynthia. I said I was trying. I spent the next week going through Linda's files. I built a spreadsheet matching the invoices to the bank statements. The discrepancies were clear. Over 3 years, the HOA had paid the tow company almost $4,000 more than the invoices showed. I cross-referenced the dates with the group chat. Every unexplained payment corresponded to a week when Cynthia had posted about towing enforcement. I took screenshots and added them to the binder. I filed another records request, this time asking specifically for all bank statements and all invoices from the tow company for the last 3 years. I sent it certified mail to the management company, the board president, and Cynthia. I got a response a week later from the management company. It said the bank statements were confidential financial records and required board approval to release. I replied that the bylaws required financial transparency, and any homeowner could request bank statements. The management company replied that the bylaws had been updated, and financial records were now restricted. I checked the website. No updated bylaws. I replied asking for the date and vote on the update. No response. I called Linda and told her. She said they were making it up as they went. I said I needed leverage. She said I needed someone inside who would leak the records. I asked if she knew anyone. She said there was a board member, a guy named Tom, who had always seemed uncomfortable with Cynthia's tactics. She said he might help if I approached him carefully. I asked for his contact. She gave me his email. I sent Tom a brief email explaining that I was investigating financial discrepancies in the HOA's towing expenditures and had evidence of potential fraud. I asked if he would be willing to talk confidentially. He replied 2 days later. He said he could not discuss HOA business without board approval. I replied that I was not asking him to violate any rules, just to confirm whether certain records existed. He replied that he would think about it. I did not hear back. A week later, I got a letter from the HOA attorney. It said I was harassing board members and interfering with HOA operations. It said if I did not stop, the HOA would seek a restraining order. I called the lawyer I had consulted earlier. I told him about the letter. He said it was a scare tactic. He said I had a right to request records and communicate with board members. He said if they tried to get a restraining order, he would fight it and probably win. I asked what I should do. He said, ignore the letter and keep going. I hung up. I ignored the letter. I kept digging. I went back to the group chat. I searched for the word attorney. I found a post from 2 years ago where Cynthia had announced the HOA was retaining a new law firm. I searched for the firm name. I found their website. I found a page listing their services. One of them was HOA enforcement litigation. I called the firm and asked to speak to the attorney handling Eagle Ridge HOA. The receptionist asked my name. I gave it. She put me on hold. A man came on the line and introduced himself as the HOA's attorney. I asked if he was aware of the financial discrepancies I had raised. He said he was aware of my records requests. I asked if he had reviewed the documents. He said that was privileged. I asked if the HOA had provided him with the bank statements and invoices. He said he could not discuss his communications with the client. I asked if he was aware that the management company had backdated meeting minutes. He was quiet for a moment. He said if I had evidence of that, I should provide it. I said I had already provided it in my records requests. He said he had not seen it. I said then the HOA was withholding evidence from their own attorney. He said he would look into it. He hung up. 2 days later, Tom called me. He said he had been thinking about my email. He said he had concerns about how the HOA was being run, but he was not sure he could help. I asked what his concerns were. He said Cynthia had too much control, and the board president let her do whatever she wanted. I asked if he had seen the financial records. He said he had seen some of them, but they were always incomplete. I asked if he had ever questioned it. He said yes, and he had been told to stay in his lane. I asked if he would be willing to request the full records as a board member. He said he had tried once and been voted down. I asked who voted against him. He said the board president and 2 other members who always sided with Cynthia. I asked if he would be willing to make a formal motion at the next meeting. He said the next meeting was not scheduled. I said the bylaws required quarterly meetings. He said the board president kept canceling them. I asked why. He said lack of quorum, but he suspected it was to avoid scrutiny. I asked if he would go on record. He said not yet, but he would keep his eyes open. I thanked him and hung up. I now had an inside source, even if he was not ready to go public. I went back to the evidence. I looked at the tow company invoices again. I noticed something I had missed before. The invoice numbers were not sequential. There were gaps. Invoice 4471, then 4485, then 4490. I pulled up the bank statements. The payments matched the invoice amounts, but the dates did not always align. Some invoices were dated after the payments. I took screenshots. I called the tow company. I asked to speak to the owner. The clerk said he was not available. I asked when he would be. The clerk said he did not know. I asked if I could leave a message. The clerk said sure. I left my name and number and said I had questions about invoices submitted to Eagle Ridge HOA. I did not get a call back. I drove to the tow yard. The same clerk was behind the glass. I asked if the owner was in. He said no. I asked when he would be back. He said he did not know. I asked if I could wait. He said it could be hours. I said I had time. He shrugged. I sat in the waiting area, a plastic chair bolted to the floor, and pulled out my phone. I searched for the tow company owner's name. I found a LinkedIn profile. I found a Facebook page. I found a news article from 5 years ago about him expanding his business. I found a lawsuit from 3 years ago, a customer suing for wrongful towing. The case had been dismissed. No details. An hour later, a man walked into the office from the back. He was in his 50s, graying hair, oil-stained jeans. He glanced at me and asked the clerk what I wanted. The clerk said I had questions about invoices. The man looked at me. I stood up and introduced myself. I said I was a homeowner at Eagle Ridge, and I was investigating discrepancies in the invoices his company had submitted to the HOA. He said he did not discuss client billing with third parties. I said I was not a third party. I was a homeowner whose fees were paying those invoices. He said that was between me and the HOA. I said the HOA was not being transparent. He said that was not his problem. I asked if he was aware that some of the invoices appeared to be backdated. He stared at me. I said I had copies if he wanted to see them. He said he did not. I said I was planning to file a fraud complaint with the state and his company would be named. He said I could do what I wanted, but he had done nothing wrong. I asked if he had records of every tow his company had done for the HOA. He said of course. I asked if I could see them. He said no. I asked if he would provide them in response to a subpoena. He said his lawyer would handle that. I thanked him and left. I sat in my car and called the lawyer. I told him what I had found. He said the invoice gaps and backdating were strong evidence of fraud. He said if I could prove the tow company was in on it, we could go after both the HOA and the vendor. I asked what I needed. He said a paper trail showing coordination. I asked how to get that. He said subpoena the tow company's records and the management company's emails. I said that required a lawsuit. He said yes. I asked how much. He said the same as before, $2,000 up front or contingency. I said I would think about it. He said do not wait too long. I hung up. I went home and looked at my savings account. I had $1,800. Not enough. I thought about taking out a loan. I thought about asking family for help. I thought about just paying the damn tow fee and moving on. But I could not. This was not about the money anymore. It was about the principle. It was about Cynthia and the management company and the tow vendor thinking they could fabricate rules and destroy records and harass people with no consequences. It was about every homeowner who had been targeted and gave up. It was about making sure it did not happen again. I called Linda. I told her I was thinking about filing a lawsuit but did not have the money. She said she would chip in. I said I could not ask her to do that. She said she wanted to. Cynthia had made her life hell and she wanted payback. I asked how much she could contribute. She said $500. I thanked her. I called Marcus. I told him the same thing. He said he was in for $300. I called the woman whose car had been towed. She said she could do $200. I now had $2,000. I called the lawyer and told him I was ready to file. He drafted the complaint. It named the HOA, the management company, Cynthia individually, and the tow company. It alleged fraud, breach of fiduciary duty, violation of the HOA bylaws, and unjust enrichment. It requested damages, an injunction against further enforcement actions, and an order requiring the HOA to produce all records. I reviewed it and signed. He filed it the next day. The HOA's attorney called me 2 days later. He said the lawsuit was frivolous and would be dismissed. I said we would see. He said the HOA was willing to settle if I dropped the case. I asked what the terms were. He said they would waive the tow fee and the violation fine. I said that was not enough. He asked what I wanted. I said full financial records, an independent audit, removal of Cynthia from any enforcement role, and a written apology sent to every homeowner. He said that was unreasonable. I said then we would go to court. He said I would lose. I said we would see. He hung up. Discovery started. My lawyer subpoenaed the bank statements, the invoices, the meeting minutes, the emails, and the tow company dispatch logs. The HOA's attorney objected to every request. My lawyer filed motions to compel. The judge granted most of them. The HOA was ordered to produce the records within 30 days. 30 days later, the HOA produced a box of documents. My lawyer and I went through them. The bank statements were redacted. The invoices were incomplete. The meeting minutes were missing entire months. The emails were heavily redacted, with whole paragraphs blacked out. The tow company dispatch logs were not included. My lawyer filed a motion for sanctions. The judge ordered the HOA to produce unredacted records within 14 days or face penalties. 14 days later, the HOA produced another box. This one was better. The bank statements were complete. The invoices were mostly complete. The emails were still redacted, but less so. The tow company dispatch logs were included, but several pages were missing. My lawyer and I went through everything again. We found the smoking gun in an email thread between Cynthia and the management company supervisor. The thread was from 2 years ago. Cynthia had emailed asking the supervisor to issue a violation notice for a specific address. The supervisor had replied asking for the rule citation. Cynthia had replied that the rule was implied. The supervisor had replied that she needed a formal citation to process the notice. Cynthia had replied, "Just put down commercial vehicle. We will sort out the details later." The supervisor had replied, "Is there a board vote on this?" Cynthia had replied, "The board trusts my judgment." The supervisor had replied, "I need documentation." Cynthia had replied, "I will send you the minutes." The next email in the thread was the supervisor confirming the notice had been sent. Attached was the fabricated vote summary, the same one Marcus had received. I read the email 3 times. It was a management company internal note admitting the violation was fabricated. My lawyer read it and smiled. He said this was exactly what we needed. He said we could now prove the management company had knowingly participated in the fraud. I asked what came next. He said we would use this in the settlement negotiations. I said I did not want to settle. He said we could still go to trial, but this email would force them to offer better terms. I said I wanted them to burn. He said patience. The next day, the HOA's attorney called my lawyer and asked for a meeting. My lawyer agreed. We met at his office. The HOA's attorney was there with the management company supervisor and Cynthia. Cynthia looked furious. The attorney said his clients were willing to make a generous settlement offer. My lawyer asked what it was. The attorney said they would waive all fees, issue a formal retraction of the violation, and agree to an independent audit. My lawyer asked about Cynthia. The attorney said she would step down from the compliance committee. My lawyer asked if she would be removed from the board. The attorney said she was not on the board. My lawyer asked what her official role was. The attorney hesitated. He said, "Welcome committee chair." My lawyer asked what authority that role had. The attorney said it was advisory. My lawyer asked if it had enforcement authority. The attorney said no. My lawyer asked how Cynthia had been issuing violation notices. The attorney looked at the supervisor. She looked at the floor. My lawyer said it sounded like the management company had given Cynthia authority she did not have. The attorney said that was an internal matter. My lawyer said it was fraud. The attorney said they disputed that characterization. My lawyer slid the email thread across the table. The attorney read it. His face went pale. He asked where we got it. My lawyer said discovery. The attorney said it was taken out of context. My lawyer said the context was clear. The supervisor had knowingly processed a fabricated violation notice at Cynthia's request. The attorney said they would need time to review. My lawyer said they had 14 days to respond, or we would file a motion for summary judgment. The meeting ended. 2 days later, the attorney called back. He said his clients were willing to agree to our full demands: complete financial records, independent audit, removal of Cynthia from any HOA role, written apology to all homeowners, and full reimbursement of my legal fees. My lawyer asked if they admitted wrongdoing. The attorney said no, but they would agree to a consent decree requiring reforms. My lawyer asked if the consent decree would be public. The attorney said yes. My lawyer looked at me. I said yes. The settlement was finalized a week later. The HOA issued a memo to all homeowners admitting that enforcement actions had been taken without proper authority and apologizing for any harm. The memo announced that a neutral hearing officer would be assigned, so appeals could be handled fairly without bias. The memo announced that Cynthia Young had been removed from all HOA roles effective immediately. The memo announced that an independent auditor would review the last 3 years of financial records and report findings to the board and all homeowners. I emailed the proof to every homeowner right before the meeting so Cynthia walks into an ambush. I sent the email thread, the backdated vote summary, the invoice discrepancies, and the group chat screenshots to every address in the HOA directory. I sent it at 8 in the morning on the day the settlement was announced. By noon, the group chat was exploding. People were furious. People were demanding answers. People were calling for a special meeting to vote Cynthia out of any remaining positions. Cynthia posted once, saying the email was full of lies and she had always acted in the community's best interest. 50 people replied, calling her out. She left the group chat. She never came back. The independent audit was completed 2 months later. The auditor found that over 4 years, the HOA had paid the tow company nearly $6,000 more than documented invoices supported. The auditor found that multiple violation notices had been issued without board votes or rule citations. The auditor found that meeting minutes had been altered or fabricated on at least 4 occasions. The auditor recommended that the HOA terminate its contract with the management company and hire a new firm. The board voted unanimously to accept the recommendation. Cynthia tried to spin it. She posted on her personal Facebook that she had been targeted by a disgruntled homeowner and the HOA had caved to pressure. She said she had always followed the rules and the audit was biased. She said she was considering legal action. No one believed her. Her own clip from the cleanup day, where she had screamed at the former board member, had been shared in the group chat dozens of times. The funny karma beat was that her own phone recording, which she had used to document violations, had been subpoenaed and showed her admitting she did not need proof, just paperwork and vibes. The lawyer had played it in the settlement meeting. She had tried to claim it was a joke. No one laughed. The new management company took over 3 months later. They conducted a full review of the rules and posted them on a new HOA website with timestamps and revision histories. They issued new handbooks to every homeowner. They set up a transparent process for violations with mandatory rule citations, photographic evidence, and a right to appeal to a neutral third party. They terminated the contract with the tow company and required a new vendor to verify every tow order with photographic proof and a signed board authorization. Tom, the board member who had helped me, ran for board president in the next election. He won. He appointed Linda as treasurer. She implemented new financial controls and required monthly reports to all homeowners. The HOA started holding meetings on schedule, with agendas posted in advance and minutes published within a week. Cynthia moved out 6 months after the settlement. She sold her house and left the state. I heard through the group chat that she had moved to Arizona and joined another HOA board there. I felt sorry for her new neighbors. My parents' health improved once the stress was gone. We had dinner together every night and I stopped worrying about surprise notices on the mailbox. I got my car back from the tow yard the day the settlement was finalized. The fee was refunded in full. I drove home and parked it in my driveway, right where it had always been, and no one said a word. I kept the evidence binder on a shelf in my office. I kept the recordings backed up in 3 places. I kept the email thread printed and framed, a reminder that paper trails matter and persistence pays off. I started a blog documenting the whole fight, step by step, so other homeowners would know what to look for and how to fight back. The blog got thousands of views. I got emails from people all over the country dealing with similar situations. I helped where I could, sharing templates for records requests and explaining how to spot fabricated minutes. Some of them won their fights. Some of them gave up. I understood both. The HOA never apologized to me directly, but the public memo was enough. The reforms were real. The accountability was real. The fear that Cynthia could show up at my door with a clipboard and a fake rule was gone. That was all I wanted. I ran into the neighbor who had spoken up at the cleanup day. He thanked me for not letting it go. He said his wife had been targeted by Cynthia years ago, and they had paid a bogus fine just to make it stop. He said he regretted not fighting. I said it was never too late. He said he was running for the board next cycle. I said I would vote for him. The lawsuit had cost more than I expected, even with the settlement reimbursing my fees. The emotional cost was higher. There were nights I could not sleep, replaying confrontations and wondering if I was doing the right thing. There were moments I wanted to quit, to just pay the fee and move on. But I did not. I stayed in it, not because I was brave, but because I was stubborn, because Cynthia had pushed too hard and I had nothing left to lose. The tip line staffer called me after the settlement was announced. She said she had seen the news coverage and wanted to congratulate me. I thanked her. She said she had covered HOA disputes for years, and most of them ended with the homeowner giving up. She asked what made me keep going. I said I had proof. She said a lot of people have proof and still quit. I said I had help. She said that was the real answer. She said no one wins these fights alone. She was right. Linda and Marcus and the woman with the towed car all got their money back from the settlement fund. The HOA had to reimburse anyone who had paid a fine based on a fabricated violation in the last 3 years. 17 people filed claims. The total was over $12,000. The management company's insurance covered most of it. The rest came out of the HOA reserve fund, which Cynthia had spent years building up through bogus fines. The irony was not lost on anyone. The tow company lost the HOA contract and filed for bankruptcy 6 months later. The owner tried to sue the HOA for breach of contract, but the lawsuit was dismissed when the judge saw the evidence of fraud. The dispatch logs we had subpoenaed showed that the company had towed vehicles based on phone calls with no written authorization, in direct violation of their own terms of service. The judge sanctioned them for discovery violations. The company closed a month later. The HOA's old attorney resigned from the case after the email thread was revealed. He sent a letter to the board saying he had been misled by his clients and could no longer represent them in good faith. The board hired a new attorney who negotiated the settlement. The old attorney was never disciplined, but his firm dropped the HOA as a client. Cynthia never faced criminal charges. The evidence showed fraud, but the prosecutor said it was a civil matter and declined to pursue it. I was disappointed but not surprised. The legal system does not always deliver justice, but the settlement and the public memo were enough. Cynthia's reputation was destroyed. Her authority was gone. Her scheme was exposed. That was the win. I learned a lot from the fight. I learned that HOA bylaws are only as good as the people enforcing them. I learned that management companies will cover for bad actors if it is easier than holding them accountable. I learned that records are power, and people who destroy records know it. I learned that most neighbors will not get involved, but the few who do can make all the difference. I learned that the legal system is slow and expensive and frustrating, but it works if you have the evidence and the patience. I also learned that I am not a natural fighter. I am a photographer. I like composition and light and moments frozen in time. I do not like confrontation. I do not like yelling matches in parking lots or sitting in lawyers' offices reviewing redacted emails. But I did it because I had to. Because someone had to. Because if I did not, Cynthia would have kept going, and the next target would have been someone with less fight in them. The blog I started got picked up by a local news outlet. They did a feature on HOA abuse and interviewed me and Linda and Marcus. The story ran on the evening news. I got calls from 3 other HOAs asking for advice. I helped where I could. One of them ended up filing their own lawsuit. They won. The reforms at Eagle Ridge held. The new management company was not perfect, but they were transparent. The new board was not perfect, but they were accountable. The violations process was not perfect, but it was fair. That was all anyone could ask for. I still live in the same house. I still park my car in the same driveway. I still take photos for a living and keep extra batteries in my jacket. But I also keep a copy of the settlement memo in my glove box, just in case. I keep the evidence binder on the shelf where I can see it. I keep the framed email on the wall as a reminder that the truth matters and lies collapse when you shine a light on them. My parent asked me once if it was worth it. I said yes. They asked if I would do it again. I said I hope I never have to. They said that was not an answer. I said it was the only one I had. The final piece came a year later. The independent auditor issued a follow-up report confirming that the HOA's finances were clean and all reforms had been implemented. The report was posted on the new website. I read it twice. I printed a copy and put it in the binder. I closed the binder and put it back on the shelf. I did not need it anymore, but I was not throwing it away. History matters. Evidence matters. Accountability matters. I got an email from Cynthia's replacement on the welcome committee. She introduced herself and said she wanted to start fresh. She said she had read the settlement memo and the audit report. She said she was committed to making Eagle Ridge a place where everyone felt safe and respected. She asked if I had any suggestions. I wrote back with 3: transparency, documentation, and fairness. She thanked me. I never heard from her again, but I did not need to. The system was working. I ran into Tom at the grocery store. He said the board was planning a community event to rebuild trust. He asked if I would speak. I said no. He asked why. I said I had said everything I needed to say. He said people wanted to thank me. I said they could read the blog. He laughed and said he understood. He said the event was happening anyway, and I was welcome if I changed my mind. I did not go. I do not like being the center of attention. I like being behind the camera, not in front of it. But I did attend the next HOA meeting. I sat in the back and watched the new board work through the agenda. They posted the minutes online the next day, complete and accurate. They answered questions from homeowners without evasion. They approved a budget with line item transparency. It was boring. It was exactly what an HOA meeting should be. I left feeling lighter than I had in years. The fight was over. The reforms were real. The accountability was real. Cynthia was gone. The management company was gone. The tow company was gone. The fabricated rules were gone. The missing minutes were gone. The lies were gone. What was left was a neighborhood that worked the way it was supposed to, with rules that made sense and people who followed them. I went home and made dinner for my parent. We ate together and talked about nothing important. The stress was gone. The fear was gone. The anger was gone. What was left was peace. That was the real win. Not the settlement. Not the memo. Not the reforms. The peace. I still keep the evidence. I still keep the recordings. I still keep the email thread framed on the wall. Not because I expect another fight, but because I want to remember what I learned. That documentation beats bluster. That patience beats rage. That the truth, backed by evidence, is stronger than any lie. Cynthia tried to rewrite the story on her Facebook. She posted once more, months after she had moved, claiming she had been the victim of a coordinated smear campaign. She said the audit had been rigged. She said the settlement had been forced. She said she had done nothing wrong. No one from Eagle Ridge engaged. Her post got 3 likes, probably from people who did not know the full story. The rest of us moved on. The neighborhood moved on. The new trees the HOA planted grew. The walking paths got repaved. The community center got a fresh coat of paint. Life went back to normal. The kind of normal where people followed reasonable rules and no one showed up at your door with a clipboard and a fake authority voice. I kept taking photos. I kept working. I kept living. The fight had taken a year of my life, but it had given me something too. The knowledge that I could stand up, that I could push back, that I could win. Not because I was special, but because I had the evidence and I refused to quit. The blog is still up. I update it occasionally with news from other HOAs where homeowners are fighting back. Some of them win. Some of them lose. I share the lessons either way. The most common email I get is, "How do I start?" I always reply the same way. Document everything. Request records, find allies, and do not give up. Some of them listen. Some of them do not. I cannot fight their battles for them, but I can show them the map. I got a message once from someone in Arizona. They said they lived in Cynthia's new HOA and she was already causing problems. They asked if I had advice. I sent them the evidence binder template and the records request templates. I told them to start building the case now, before it got worse. I do not know if they followed through. I hope they did. The settlement money got split between me, Linda, Marcus, and the woman with the towed car. We each got about $1,000 after legal fees. It was not much, but it was something. More importantly, it was justice. It was acknowledgement that we had been wronged, and the system, slow and frustrating as it was, had worked. Linda used her share to take a vacation. She sent me a postcard from Hawaii. She said she was finally relaxed for the first time in years. Marcus used his to pay off a credit card. He said he wished he had fought harder when it was happening to him, but he was glad someone finally did. The woman with the towed car used hers to donate to a legal aid fund for HOA disputes. She said she wanted to help the next person who could not afford a lawyer. I used mine to upgrade my camera gear. I figured I had earned it. The new camera had better low-light performance, which came in handy when I was photographing a wedding that fall. The couple asked why I was smiling during the reception. I said I was just happy to be there. They did not need to know the rest. The HOA issued one more memo a year after the settlement. It announced that all reforms had been completed, and the organization was now in full compliance with state law and its own bylaws. It thanked the homeowners for their patience during the transition. It did not mention Cynthia by name, but everyone knew what the memo meant. The old regime was gone. The new system was working. The page had turned. I printed the memo and added it to the binder. I closed the binder one last time and put it on the shelf next to my camera gear. I did not need it anymore, but I was keeping it. History matters. Evidence matters. The fight matters, even after it is over. Stay calm, stay documented, and I will see you next time.